All rise. First District Court of Appeals now in session. All who have business before this court draw near, give attention, and you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Please be seated. Good morning. Welcome to the First District Court of Appeal. We have one case on the docket this morning. It is Shands Jacksonville Medical Center et al. Versus Jennifer and Marlon Chavez. It's 2020-3605, and we're having oral argument on the motion for rehearing. Ms. Davis, are you ready? And I understand you're splitting the argument, and I'm going to leave that up to you when that break occurs.
Thank you, Your Honor.
Okay.
Christine Davis here on behalf of the appellants. As you mentioned, I will be splitting time with NICA. We decided, I know that I'm responsible for the time, but just so you know, our plan is for me to take 8 minutes. Mr. Usina would take 7 minutes, and then I'll reserve 5 minutes for rebuttal. So we raised several issues in our motion for rehearing in this case, and the first one I'd like to address is that the court should have accepted our notice of voluntary dismissal that we filed after the oral argument in this case. After the first oral argument in this case, it became clear that the court was considering.
So that notice is still pending.
It was denied.
Well, it's still extant. You're standing by it.
Correct.
Okay.
Correct. And we raised it in our motion for rehearing that it should have been granted. And after the oral argument in this case the first time around, it became clear to appellants that the court was considering fundamentally altering the nature that NICA has been implemented for the past 25 years. And we believed the responsible decision would be to dismiss the appeal and allow the issue to be addressed in a case where the issue was properly raised. Because what was discussed was primarily a constitutional issue.
Hasn't that concern now kind of dissipated given the additional briefing or motions that have been filed and the amici that have been submitted? Your point in your original motion or request for voluntary dismissal was all the stakeholders aren't here and we haven't fully understood all the implications and everything. Isn't that kind of past?
Well, I don't think that excuses the established rule that a party and not a court should raise the issue, and a court should not raise issues on behalf of the party. And the briefing that we've had has all been reactive. So the court asked in its supplemental briefing whether the ALJ has jurisdiction. All parties agreed under binding case law, including from the Supreme Court, that that the ALJ did have jurisdiction. Then it flipped a little bit on appeal, and in the opinion, the majority panel opinion said, we asked whether we had jurisdiction, meaning this court. That wasn't a question that was asked to us. So we had to sort of reactively brief that as well. So I don't think it's been, I appreciate that we've been given the opportunity to brief, but it's all been reactive briefing. And this, I think the reason that judges aren't supposed to sua sponte raise constitutional issues on behalf of a party is so that it can be raised properly and fully fleshed out by the party and fully considered by the court. And that's an important principle of judicial restraint, and we cited a case from this court that makes that clear.
Well, with respect to a motion for rehearing, typically you would argue that we overlooked something. Are you arguing that the panel or the majority overlooked its discretion or misapprehended the scope of its discretion to grant or not grant a voluntary dismissal?
That's one of our arguments.
And what aspect of discretion are you saying that we overlooked?
We think, I acknowledge that the court has discretion to keep cases under certain circumstances when a party has voluntarily dismissed them, but we didn't think this was the appropriate case. The only reason given for the dismissal was that the court had expended judicial labor, but then the court went on to expend almost 2 additional years of judicial labor only to find that it had no jurisdiction over the appeal. So in essence, the outcome was the same. The appeal is dismissed, which is what we had asked for to begin with. So we don't think that that was necessarily a valid basis to exercise discretion and keep an appeal. And we have an amicus brief filed by the university self-insurance programs that fleshes that out more.
Right, which suggests that one of the bases is great public importance, which it seems like both NICA and your clients acknowledge this matter is of exceptional importance.
Given the opinion that was issued, the majority panel opinion that was issued, that is certainly a question of public importance, but it was one that was not raised by the parties. So if we are having to deal with this opinion and it's going to be out there, it is certainly of great public importance because it upends 25 years of precedent that has implemented NICA, including decisions from the Florida Supreme Court.
So
And
the-
essentially, I'm sorry.
So the initial question presented to this court was basically whether competent substantial evidence supported Judge Rosava's findings, right?
Exactly. It was just a routine appeal from a NICA compensability determination by an ALJ, and it didn't raise nobody raised jurisdiction, and in fact, no party could have raised jurisdiction. One of the issues when you're thinking about jurisdiction is the court in the majority panel opinion held that the ALJ's opinion was advisory because it didn't have jurisdiction to enter it. Well, in reality then, this court's panel opinion is advisory because it's saying it doesn't have jurisdiction to review it, and the ALJ had no jurisdiction to enter it. But if you
And
take
it seems
that,
like to me what we ruled before is kind of a two-step process. We had to find a basic unconstitutionality, an unlawful delegation of authority in order to give us the hook where we found that we didn't have jurisdiction.
and I don't think so. Right, but constitutionality is not a hook for no jurisdiction. Either, I don't think that you can say, otherwise an appellate court would always be able to say, I don't think this statute is unconstitutional, so I'm going to raise this on behalf of the parties, even though no one questioned it. For whatever reason, they decided not to question it, whether they didn't think of it, they strategically decided not to, they didn't want to go there, or established law was to the contrary and they didn't want to take it on. A court cannot raise a constitutional issue on behalf of a party. It can say it doesn't have jurisdiction, but that's separate from saying it's unconstitutional. Because, if you think about the ramifications of that, in any case, the court would be advocating for a party or departing from its dispassionate role and advocating for a party that a statute is unconstitutional when nobody raised that issue.
So let me see if I understood you. You certainly agree that we can find that we don't have jurisdiction at any case, any point along the process.
Yes.
But we can't go back and say, we think this statute's unconstitutional and therefore we don't have jurisdiction.
Correct.
So you would say the distinction is, we can always look at an order that's on appeal and say, this isn't an appealable final order, we don't have jurisdiction, we can raise that on our own.
Yes.
It's different from the statutes that purport to give us jurisdiction are invalid under the Constitution, so that's distinct.
I think
One's raising a
so.
constitutional issue under the guise of raising a jurisdictional issue.
Correct. Because that goes into that you're going into a substantive merits issue of whether a statute is constitutional or not. And that should be something that's raised by the parties. And as an example here, if we would have been before the DOA in this case, and someone would have said, ALJ, you don't have jurisdiction over this case because even though no court has ever said this before, a filing of a petition under protest equates to a voluntary dismissal, the ALJ would have been bound by all of the existing precedent from the last 25 years that says that's not true. You have jurisdiction to make the threshold determination of compensability and to determine whether notice was given. And if a civil action has been filed and if a civil action has been filed and exclusivity is raised as an affirmative defense, you have the requirement to abate that civil action and have an ALJ determine whether the exclusive remedies apply. That's what every case before this court's panel opinion decided. So the ALJ would have been bound by that. And that just shows, this creates entirely new law And it's not something even the ALJ could have been bound by below, because that's not, he's bound by, even if you would take, we would disagree with this, but even if you assume that this court has not specifically ruled on that issue, we think that it has addressed it in Tabb and in Macri and in Putnam. But it's definitely clear that the second, third, fourth, and fifth DCAs have held to the contrary, and the ALJ would have been bound by those decisions and would have been required to make a compensability determination as a threshold issue before a civil action can be brought, because the statute, section 766-304, which was amended after 1998 in response to McCon, said no civil action shall be brought until a compensability determination is made.
So if someone would have raised a constitutional issue before the ALJ couldn't rule on it.
The ALJ couldn't rule on it.
But you still have to present it.
You have to present an as-applied challenge to an ALJ. You could raise a facial constitutionality challenge for the first time on appeal, but it has to be raised by a party. It's not supposed to be raised by the court on behalf of a party, and nobody did that here.
Is standing under 12068 1A jurisdictional?
I think that provides the circumstances under which this court has review of administrative rulings. So I think it sort of implements the constitutional provision that this court has jurisdiction to review final orders of an ALJ.
So if your clients were not adversely affected by the ALJ's order, then we wouldn't have jurisdiction over your client's appeal. Is that correct?
I think that's technically true, but we were adversely affected here because.
In what way?
Excuse me?
In what way?
Because we have a right, and this court's decision in Putnam recognized a healthcare provider's right to intervene, and their important interests in intervening in those cases, because to argue that NICA is the exclusive remedy. That's why they pay into the plan, and that's why they participate in the plan, which is the whole purpose of the act. And so when the ALJ said this isn't compensable, that is adverse to us, because we were taking the position, in addition to NICA taking the position at the time of the final order, that it was compensable. The majority panel opinion kind of glosses over the fact that NICA originally thought this was not compensable, but they changed their mind. So at the time of the final order, there was a dispute over compensability. And there's been many cases, including coming to this court, where a healthcare provider appeals the ALJ's determination of compensability, and no court, despite their independent obligation to examine their own jurisdiction, has found a jurisdictional issue with respect to that.
But just because the basis, I think this court has even said that being allowed to intervene in an administrative proceeding is insufficient to support standing on appeal by itself. So the
Not
fact
standing on appeal.
Right, standing on appeal.
You're subject to the claims, but interveners can appeal.
They can,
Yes.
yes, because they're a party, but you still have to show that they're adversely affected. And
Which-
you can't use just the fact that you're allowed to intervene in the administrative proceeding as a
Well,
basis for the adverse effect.
And that's not what I'm suggesting. Once you're able to the reason that they're able to intervene is because they have a direct interest in determining whether NICA is the only available remedy to the claimant. And so when the ALJ says this is not compensable, and NICA and or the healthcare provider says this is compensable, that adversely affects us, because we believe the injury is subject to the exclusive remedy under the plan, and they should not be able to sue in civil court for medical malpractice.
Sure, but that affects the claimant's rights, not the provider's rights. If you look at the entire chapter, this part of the chapter, there's really no reference at all to a single right on behalf of a provider.
The
It
provider.
speaks in terms of the claimant's rights.
I don't think, I disagree with that to a certain extent, because while it says a claimant brings a petition seeking benefits, that the healthcare providers also have rights. Everything is not in the hands of the ALJ. This is a procedure whereby the parents get notice, they sign the notice, so they've effectively waived their right to medical malpractice if it's a NICA compensable injury. So they know this going in. And so the threshold question that has to be made is this compensable under NICA? If it is, then that's their exclusive remedy, and that's what they have to take. If it's not, then they're allowed to proceed to circuit court. And I think I'm eating into his time, so I'll defer.
Did you get your question answered?
I won't interfere.
Okay, we'll hear from Mr. Asenia, and I'm going to give you some extra time for rebuttal because we had lots of questions, and as a lawyer, I learned that splitting time, it's never it's always a mess.
Thank you, Your Honor, because I would only have 50 seconds if we were going to strictly
Right.
adhere to the timeframes.
You can use the remainder of the time, and I will give some rebuttal.
Thank you, Your
time.
Honor. May it please the Court, I'm Steve Asenia, and along with my colleague Tana Story, we represent NICA in this appeal. Unless the opinion in this case is vacated, the majority opinion will upend the way NICA claims are litigated, creating a situation where doctors and hospitals that have been relying upon an administrative law judge to determine compensability under NICA will be forced to defend lawsuits in circuit court, wherein their NICA protections can only be raised as affirmative defenses, and then be ping-ponged back to DOA if the court finds that the claim is compensable. This is
Couldn't they written the NICA statute to mirror the comp statute and obviate the concerns that Judge Tannenbaum has raised in his opinion?
Well, I believe that the legislature directly responded to McCon, and I think a lot of the decisions that have followed since the legislative changes in 1998 were made reflect that. But could the statute, I think when we're looking at statutes in hindsight, we can always find ways that they should have been drafted more clearly or more precisely.
Yeah, well, I think that Judge Tannenbaum, in his opinion, certainly understands that the legislature wanted a process where a person had to go through this administrative process before they went to court. But the argument is that the legislature doesn't have the authority to take away the inherent powers of courts to decide issues like this, and they did that.
Well, I don't believe that the inherent powers of the courts have been abrogated here because, look, if somebody, you've got a choice. You have a choice here. Everybody is required, the providers are required to provide notice to anybody who's going to deliver a child that they are a participating physician in NICA or they're a participating hospital. But
if you go before the ALJ and they say it's a birth-related they grant and say it is a birth-related neurological injury, at no point can you cannot go to a court at any time and say the ALJ got it wrong.
Well, Your Honor, but you can come to this court and appeal that decision, and you can also go if you demonstrate willful and wanton.
But you can't go to circuit court and have a different fact finder look at it.
You can't, but that provider could. My point was going to be, Your Honor, that the person delivering the baby could choose a different provider. They could choose a provider that's not participating in the NICA plan and have the right to sue in circuit court if malpractice is committed. But they voluntarily give up that right to go to circuit court when they agree to accept a NICA participating physician. And that's what the legislature intended when you look at the entirety of the statutory scheme. I know that obviously.
So you may not have this, but do you have any data on how many obstetricians are NICA versus non-NICA?
There are, I wish I did. I know that there are obstetricians who choose not to participate in the NICA program. I can maybe get that information if my colleague has it, but I don't know the number.
Okay.
And certainly I would acknowledge that there are a majority of obstetricians in the state participating in the NICA program, but there are others that don't. And I think and that's the whole point of giving notice. I mean, you're putting somebody on notice that they have, if they accept NICA and if they accept a provider that participates in NICA, they then have to go through the administrative hearing process.
To seek what?
To seek what?
Yeah.
To seek a determination of compensability and to determine whether notice has been provided.
Is that what the statute says? Because when I read the definition of claimant and I read the other provisions, and I think even the briefing or the motions acknowledge that, well, technically, if you read the statute, yeah, that's what it says, that it has to be a parent or child seeking compensation from the fund for it to be a claim. So in this case, we don't have someone seeking compensation from the fund. So where's the claim?
I appreciate that, Your Honor, but I think you need to look at the entirety of the statute and the legislative changes that were made after McCon that talk about the exclusive jurisdiction of DOA to determine NICA claims.
Right.
And
if
I
there is a
know
claim,
that
doesn't that mean that
but-
if a parent or child wants a remedy for BRNI, that the only place they can go for determination of whether they're entitled to money from the fund is an ALJ?
that's true.
That's what exclusive jurisdiction would mean.
Right. And I believe that that's what the legislature intended by making these changes, and I think that that's what the courts have determined ever since. I
And
think
the
that
legislature wanted these claimants to be basically forced claimants. They have to be claimants whether they want to be claimants.
I think in the last oral argument, Judge Tannenbaum used the phrase that it was alternative dispute resolution. That's not exactly the phrase
Yeah.
you used, but essentially a pre-suit notification program, and it is. I mean, essentially, you go to DOA to have your claim determined whether it's compensable or not. If it's willful or wanton, it goes to the circuit court. If the claim's not compensable, it goes to the circuit court. And I think that the cases of DOA versus NICA and Bennett both recognize, in all of the cases that have been appealed in the many circuit courts, there are countless examples of claims where NICA benefits were disclaimed and petitions under protest were filed. And none of the other circuit courts, and even this circuit court in Tab, recognized that the issue of the claimant, and it's, look, it's a very close reading of the statute. I acknowledge that, but I think that you're looking at that specific provision in isolation. And I think that you have to look at the totality of the statute and look at what the legislature intended to do here.
If the legislature intended for the ALJ to be a substitute for the circuit court on the question of compensability, whoever's, we want, as a matter of fact or as a matter of law, we want the ALJ to determine it to the exclusion of the circuit court, why not add a provision that provides or specifies that the providers can be parties? I'm not saying they couldn't intervene as parties, but the statute is still, even with the amendment, silent on the parties besides just NICA and the parent.
But I mean, if you look at the prefatory section in section 766.301, because obstetric services are essential, it is incumbent on the legislature to provide a plan designed to result in the stabilization and reduction of malpractice insurance premiums for providers of such services. The costs of birth-related neurological injuries are particularly high and warrant the establishment of a limited system of compensation irrespective of fault. The issue of whether such claims are covered by this act must be determined exclusively in an administrative proceeding. I think that prefatory language governs what has to happen in these cases. And I accept your position that the definition of claimant confuses that issue. But I think when you look at the entirety of the statutory scheme, the changes that were made in 1996, the changes that were made, the changes that were made after McCon in 1998, the 2003 amendments and the 2006 amendments all bolster that argument.
Could a provider file a petition to have determination of compensability?
No.
Why not? I mean, it's consistent with the system that you just described, even though the statute doesn't provide for it.
Because the way the statute was designed, the person who would avail themselves of the NICA program, whether they are doing so under protest or they're doing so voluntarily, has to file that initial petition. And the statute does say that. And I'm sorry, I've eaten into our rebuttal time as well.
That's all right. Here's what I'm going to do. I'm going to add 5 minutes for rebuttal, so you'll get a full 5 minutes. And so you have 25 minutes to speak if you want to use all that time. Thank you. All right, thank you.
Thank you.
May it please?
Hold on a second while the
Yes.
clerk gets the count, the clock set.
Thank you.
All right, you may proceed.
May it please the court, Carol Link on behalf of the Chavez family. This appeal presents a very simple, straightforward question of statutory construction. and constitutional issues, as Your Honor noted in the opinion. But the actual words matter. And this court knows, Judge Roberts, you and I are new to this case as of this rehearing, but we're not new to the principle that Florida courts follow, which is the supremacy in text principle, the Ham decision from the Florida Supreme Court. The actual words matter. And they matter more than the legislative intent. So in looking at this statute and the 1998 amendments, the legislature left intact the crystal clear definition of claimant, and the claimant can only be one person or the personal representative of that child seeking NICA benefits. It's crystal clear throughout the statute, not just in the definition. We must strictly construe the statute. The Florida Supreme Court has told us that in McConn and in Bennett, which is post-1998 amendments. What Shands and NICA want this court to do is judicially rewrite this statute.
But I know you're defending the previous opinion presented by this court.
I am, yes,
But
Your
below, you didn't argue that.
Well, I'm glad you asked that. Record site 111, my client filed the petition under protest, which this court noted, and raised a constitutional argument in that petition and said the NICA statute, as interpreted, is unconstitutional. Now, that doesn't mean that this court found it to be unconstitutional. It was judicially rewritten or rewritten by Shands and NICA. What Shands and NICA want this court to do is rewrite the claimant definition. The legislature, as this court noted, left the definition of claimant intact, and the amendments under 1998 did not change how this system works and who seeks benefits, who files the claim. It's the claimant that commences this process. The rewrite of the NICA statute would make it a clearinghouse, would make it a condition precedent, and those words do not exist in the statute. Two examples of why it doesn't work the way Shands and NICA want it to work. You have a child with cerebral palsy who is physically meeting the definition under BRNI, physically, but has an IQ of 150. That child will never, ever meet the full definition of a birth-related neurological injury. However, Shands and NICA want that child who has cerebral palsy, is in a wheelchair, but with 150 IQ, to go through 2 years plus in the NICA, I say the NICA world because it's the NICA DOA administrative quasi-judicial process plus the appeal, and that's what we have in this case. My client.
So are you saying that if the child is severely physically impaired but has good or great cognition, they
Right.
would never apply?
Never apply. Never apply. And that is what Chavez is in this case. We took the position that we don't have mental impairment that meets the definition of the statute.
Well,
The
originally.
Are there neurological injuries that are not, that does not impair your cognitive ability?
Oh, sure. Yes, absolutely. But it's a farce, or I think the court, during oral argument and in the opinion, may have even used the word charade to force my client to seek benefits when my client will never meet that definition. And, by the way, my client isn't seeking the benefits, doesn't want the NICA benefits. So to interpret the statute that way, the words don't exist. They simply don't exist.
Just to clarify the history, so originally your clients filed pro se.
That's
a
correct,
petition
yes.
And sought benefits.
The
NICA then said, no, you don't get benefits. You don't qualify. And then, I guess, they got a lawyer, and they filed an amended petition that said just what you said, which is, we don't want it, we're not claimants, we don't want money from the fund.
Right, we amended before there was an ALJ determination, but
No,
yes.
but NICA.
Oh, NICA, yes, NICA
Did
flipped.
a review of the pro se petition,
Right.
decided that,
No benefits.
No benefits.
Then
You
we
didn't-
filed under protest, NICA changed its mind during the proceeding, and then during
but
the
was it a
last.
filing under protest, or was it a disclaiming of a claim? Because it's unlike some of the others where, yeah, we're seeking benefits, but we're protesting the whole thing, but you give it to us, I guess, if you want.
Oh,
Your petition, your client's petition actually said, we are not claimants.
Correct, multiple times. I mean, we, not just in the title, in the body, we say, in the title, we say under protest. In the body, we say, we are not claimants. And then in the prayer for relief, we say, we don't want benefits. We do not want compensation, just to make it crystal clear where we're headed. Another example that I'd like to give the court.
So do you think that if you're correct, or any parents who have a child that has a mishap during birth, or is anybody going to file under NICA?
Is anyone going to file?
Yeah.
Oh, yes, absolutely. NICA is an excellent program for those parents who have a birth-related neurological injured child that meets the statutory definition. They can file under NICA and get a faster proceeding with a limited remedy, right? It's capped, but they get a faster proceeding for relief and redress of their injury if they don't want to go over to circuit court. But there has to be, if you interpret this statute as you must, under the plain and crystal clear words, the actual words, there has to be the ability for my client to seek redress in a court of law. Here's another example why Shands and NICA's argument does not work. If a child is born under the 2,500 gram weight limit, that's in the definition of the statute. You are not a birth-related neurological injury if you're under 2,500. And this happened in the Exposito case, the third DCA. Judge Tannenbaum, you noted that decision in the Chavez opinion and in the McDonald case. When you're under that birth weight at birth, that's never going to change. No alternative universe is going to make that baby weigh more at birth, right? It's a concrete number. That will never be a compensable claim under NICA. Those parents should not be dragged and forced and compelled, as they were in Exposito, to file a NICA claim seeking benefits that they're going to be denied. We all know it's a farce. They're going and knocking on NICA's door and being forced to ask for benefits that the ALJ will never give them. So why force those claimants or those persons with injuries to go when they will never meet that definition? The statute doesn't say what Shands and NICA wants it to say.
So I think I agree with you on legislative intent. I mean, I don't know if there is such a thing because there's 161 different actors to pass a bill.
Right.
And they all may have different intents. But to what extent are we allowed to look at the purpose of, the overall purpose of a statutory scheme and determining what the words mean?
Yes, thank you. Well, you are governed by the Ham versus portfolio case and supremacy in text, which gives priority to the actual words over the legislative history, what others say it means. And when you look at the 766301, that's the legislative findings and intent, tells you why they did it back in 1988. Look at the 1998 amendment, because that's what Shands and NICA are arguing. They're saying that that amendment changes things. It changes the world, and it makes it clear that you have to go through NICA. But it doesn't. It's in subsection 1D. It says the issue of whether such claims. Now, the legislature did not use the word injury. Injury would have been broader, and words matter. Injury would have encompassed more. Now, I'm not suggesting that that would have been enough. They would have had to alter the definition of claimant and say what Shands and NICA want this court to say is that any child who suffered a birth injury must first seek NICA benefits, even if they don't want them, even if they don't meet the definition, before seeking redress in circuit civil court. But that purpose, that legislative intent under 766301 tells you what this purpose of the statute is. And nowhere, Your Honor, nowhere in 301 did the legislature say that this is a condition precedent to filing a lawsuit. And we know the legislature knows how to write those words. It's not difficult. They did it in the medical malpractice statute, 766104. They say no action shall be filed unless you go and get your expert opinion report. They did it with the intent under medical malpractice statute, 76102. They require pre-suit notice. They say in plain words, before filing a complaint, knocking on the courthouse doors, you must notify the defendant. So they know how to do it. And then just 2 years ago, I think it was 2 years ago, the legislature amended in response to the first party property crisis in Florida. They amended, or they created a statute 627.70152 and said as a condition precedent to filing suit. Nowhere in this statute, in the amendments of 98 or elsewhere, dating back to 1988, did the legislature use the words condition precedent. The closest they get, which does not ring the bell, is the 98 amendment to 304. And even in that amendment to 304, they said the ALJ has exclusive jurisdiction to determine whether a claim filed under this act. What's a claim filed under this act? Well, we know it's the definition of a claimant, because under 309, the only way this process can ever start is if a claimant files a claim for benefits, and if the claimant has demonstrated to the satisfaction of the ALJ. It doesn't say if the medical provider, healthcare provider has demonstrated. I think Shands in one of their briefs said, well, we just flip that burden and the medical provider can demonstrate. No, that's not what the legislature wrote. The legislature wrote if the claimant has demonstrated, and you can't change those words or rewrite them.
But you can't deny the fact that a provider can participate in the proceeding before the ALJ.
I'm
right?
sorry, Your Honor, I'm not hearing you well.
No, that's okay. You're not denying that the providers were entitled to or could participate in the
No.
proceeding in front of the ALJ.
Intervention has been allowed.
Right. And
By-
in fact, under Chapter 120, the allowance for intervention or who can be a party is much broader in the administrative proceeding, right?
True.
So let's say instead of the proceeding being perhaps unauthorized or whatever you want to call it, or advisory or whatever, the proceeding is fine. It went forward the way that the statute contemplates, maybe unorthodox, but it did. How do you address the, obviously your opponent thinks that the providers are adversely affected by the final order. What is your response to that?
Yeah, I don't see the adverse effect. I don't see the adverse impact to them. They still have their rights, and I presume that under your hypothetical, I'm actually seeking benefits, not like the Chavez family.
I'm not
So
sure.
how are the providers
not
not
sure now.
adversely affected? I mean, the whole program sets up to limit the amount of damages. So you get a streamlined administrative process.
Correct.
But you give up, they certainly want to have this covered by NICA because it
Right.
limits the amount of money that they're going to have to pay out of pocket.
Correct. Well, and don't forget it also, if I decide to decline, if I wanted those, if I filed and I didn't file under protest, if I filed and said I want the NICA benefits, the judge says you're compensable, and I decline the award before I accept the award, I can go over to Circuit Civil, but now I have to prove more than simple negligence. There's an exception. I have to prove the higher burden of proof. So it does give them a benefit with going through the NICA statute. They get the higher, but
Where I was headed with the question is can you identify, because I still didn't hear from the other side, can you identify somewhere in this part of Chapter 766 where that specifies that the providers have some sort of right or privilege even?
I've scoured the statutes. I've cited, I've printed them.
It's all
and
based on the claimant. It's focused on the
complete-
child and the parents. Is that right?
repeatedly throughout all of these subsections, from 301 to the end of what is now 311, regarding the conclusiveness of the award. The words used by the legislature is claim and claimant. And you won't find in 309, like I said, if the claimant has demonstrated, you won't find the words healthcare provider, medical provider, or even NICA. If NICA has demonstrated, the legislature did not write that. And if they intended to address McCon in some fashion, as the argument is, they just simply didn't ring the bell. And this court cannot abrogate legislative power. They have the right to put pen to paper and write the statute. What this court's job is to look at the statute in the plain words, the actual words used, and give the clear meaning. It's not just the definition of claimant, but you certainly must start there. You can look through each one of these sections in the Act. 304 is important. It's even the amendment of 304. It's claims filed under this act, a claim filed under this act. It refers to 309. 309, you go to 309, and that's the one where whether the injury claimed, if the claimant has demonstrated, it's consistent throughout the act, the use of the word claim and claimant, and not the broader term of an all-encompassing injury, was intentional by the legislature since 1988. It was left undisturbed, as this court noted in its Chavez opinion. The definition of claimant was left intact, remarkably, I think is the word that was in the opinion, and that's true. It has been.
So
This
what
court-
is the effect on the tolling provision in 766-306 if the majority opinion's view stands that there was no claim pending and no claimant? Because the tolling only is in effect if there's a claim.
I
So
know.
how does that?
It's a great question. Well, the law is, up until the Chavez opinion in December, sporadically throughout the DCAs, I know the argument is that this court previously has said that you must file a NICA claim, but it hasn't. There's no decision. It has noted that a petition was filed under protest, but there's no decision from this court saying it's a clearinghouse. NICA's a clearinghouse. You have to do that. So it's a great question, Judge Nordby. Under 766-306, it says the suit will be tolled by the filing of a claim. So the filing of the claim reverts back to the definition of claimant, reverts back to 309, how this process gets started. And so there are other tolling issues that I think
But if
could,
there's no claim here, then there's no tolling. Like if what the majority,
right,
held stands, then.
then there's no tolling. Well, there's no claim
And then
seeking
for the
benefits.
For the child and the family here,
Right.
then I assume the statute of limitations is run at this point.
Well,
What's the effect of all this?
yeah, that's a great, and I appreciate the question. It is of some concern. However, NICA and Shands have taken the position, we've sent them a letter of intent. We wanted to sue them, and they wrote back, no, go to NICA. So there's some tolling, I think, with the behavior of the parties in this case that will benefit my clients. But my clients, I mean, the record is what
They
the
were
record.
operating under, go file a claim, everything will be told.
I'm sorry.
So-
We haven't sought benefits. I mean, we can't say that we have, because the petition is very clear. It was under protest, we didn't want the benefits, we said we're not claimants.
And that doesn't change, I mean, there's nothing in the opinion that was written that changes any of that. Because you said, like, up until the opinion came out, it was like the state of affairs was one way, and now it might be the other. But the opinion doesn't really.
No, the
I mean,
opinion,
everyone agrees that the claimant has to seek compensation for it to be a claim.
the claimant has to seek compensation in order for there to be a claimant. This
It's
is
my
the,
understanding they have to file a claim to receive the benefit of tolling, though.
they have to file a claim seeking benefits, and for the 306, as Judge Nordby just asked, for that tolling to be triggered. That is true. I don't think that the tolling,
So if there was not a claim, the Chavez have no forum that they can go to.
Chavez had to go through the NICA process because of the construct that Shands and NICA have created, and have done not just in this case, but other cases. I know I was here before
But
this.
But if under the plain language, they're not claimants,
They're not.
okay,
They're not. It's,
okay.
And whatever we did with respect to the motion for rehearing isn't going to change the position of your clients vis-à-vis the statute of limitations. Is that?
it shouldn't, because of the fact that there have been actions and behavior by the parties in this case that should toll the circuit court proceeding.
And that's
We'd
your
like to
separate
go.
litigation plan. I mean, that's
Right.
that's something that you're going to address regardless of what happens here.
Correct. I have to, because I can't tell this court in good faith that we are claimants. We're not. We filed under protest. We said we're not claimants. So we didn't want NICA benefits. What this court has done, which no other court has done previously, was explain in very fascinating constitutional explanation about public rights, quasi-judicial officers, and the NICA plan versus private rights under Article 5 judges and where this rests. This court does have jurisdiction. To address Shan's point right off the bat about jurisdiction, this court knows that the Pino case gives you the right to retain jurisdiction if it's question of great public importance or likely to recur. The stakeholders have been heard. Your Honor noted that. That was the purpose of allowing for them to be heard, and no one asked to be orally heard of those amici here today. The court always has the obligation, not just the discretion, but the obligation to question its general jurisdiction. That's the West 132 feet case that this court cited, but it's also this court's decision from 2024 in Re Doe 23B. The examination of jurisdiction is a matter of primary concern to which we must address ourselves sua sponte. That's this court saying it. So to argue that you don't have jurisdiction, you may always look at your jurisdiction. The opinion did not declare the statute unconstitutional. You did not say that. You explained why you lacked jurisdiction, which was an appropriate thing to do. Just dismissing it would leave the parties without any explanation as to why you were dismissing it and how the statute works.
Yeah, this is in the context of a motion for rehearing. I'm still trying to understand the argument. Okay, so they asked for us to voluntarily dismiss, or voluntarily asked us to dismiss it. We didn't, but we dismissed it, but we explained why. Is there any difference between that and saying, okay, you don't want to litigate anymore, or you don't want an answer, fine, we're going to dismiss it anyway because you didn't have standing, let's say.
Right.
Is there much difference between one and the other? I mean, why do you think that that's actually an issue in this motion for rehearing? If we exercise our discretion
Right.
to write an opinion as opposed to saying nothing.
On
Now
your,
they're saying you misapprehended your discretion because you should have said nothing
Right.
when you dismissed the case.
Well, I think that's a question for Shands and Nika. I really don't know. I think I can guess they don't want the court saying what the court did, which was reading the plain words of the statute and giving meaning to the actual words and how this plan should operate, how the statute should operate. But you're entitled to explain why you're declining to accept jurisdiction. And it's important in this case because it is likely to recur. It's likely to recur. There are other NICA claimants, those of the babies who are born who are under the 2,500 grams or who have no mental injury but cerebral palsy and physically injured. So this opinion from this court gives great guidance to those behind the Chavez family.
Really, in what way? I wrote the opinion, but I hope it's not being overstated, the effect of it. And so from your perspective, and let me just alter it, if we were just talking about standing, and
Yes.
if the opinions said everything it said, but said that, well, the providers are not adversely affected by this order because the entire plan is focused on the claimant or the parents and the child
Seeking benefits.
seeking benefits. And we said, okay, it's fine. You participated in the proceeding below. That was you were entitled to do that, providers, but you're not adversely affected, so you can't appeal the determination of non-compensability.
Right.
How does that upend the entire program and the entire apparatus and create chaos? I think that was the word.
It doesn't create chaos. It doesn't upend. It gives some clarity.
I mean, isn't it just a
But it-
procedural question? I mean, is we do or don't have jurisdiction or based on standing from a provider when they seek review of a non-compensability determination?
Right. The problem, or it's not a problem, it gives clarity to those courts who have, circuit courts, who have stayed the circuit court proceeding and compelled clients like mine to go to NICA. This court's opinion makes it clear as did the Florida Supreme Court and Bennett, by the way. Even though Bennett talked about the rebuttable presumption, Bennett has language in there that's very consistent with the Chavez opinion. And that Bennett case is post-98 amendment. In the Bennett case, the Florida Supreme Court held that where an individual is not seeking comp under the NICA plan, but instead seeks to establish the right to sue in a court of law, that individual is not a claimant. Now, in Bennett, they said not a claimant for statutory purposes of statutory presumption, but that's the same concept. So what this opinion will do in terms of helping families behind the Chavez family is understand that they can't be compelled to go to NICA when they believe they're not going to fit this definition. And it will help us avoid this under protest charade, which Shands and NICA, or not just Shands, but other healthcare providers have forced us into this box. That's not what the legislature wrote. And they certainly do know how to write conditions precedent to suit. They did not do that here. I don't know if that answered your question, if it did. And I know I've got a little time left, but I don't need to.
No, you're past your time.
I'm past the time, yes, I am.
Sum up quickly, please.
Thank you for the additional time, and thank you for your time today.
All right, thank you very much.
So I'll start with one point that opposing counsel just made, which is that Shands and NICA created this problem. The cases created this setup. The Florida Supreme Court, District Courts of Appeal, they have all held that the NICA compensability determination is a threshold determination that must be made before a civil action can proceed, and that's consistent with the plain language of 766-304 that says no civil action can be brought. And in the Bennett case that we were just discussing, and obviously this court is bound by Bennett, when they were discussing whether the rebuttable presumption applied, the court said, we hold that where an individual is not seeking compensation under the plan, but is instead seeking to establish the right to sue in a court of law, the burden of proving compensability shifts to the healthcare provider or NICA, and they are not entitled to a rebuttable presumption of compensability. The Supreme Court, through this holding, acknowledges that this is the procedure that it believes the legislature required. And so they're seeking instead to establish a right to sue in a court of law. That's the way this is required to go. So
Did
going
the
to the
Supreme Court
plain.
consider it all in that case?
I'm sorry?
I don't think they did. Did the Supreme Court or the first DCA, I think, before that, consider the question of standing in that case? Or they just take it as a given that the
The
process happened
second
what it did
DCA in Bennett, before it went to the Supreme Court, did consider that, and they found the appellate court had jurisdiction and that the healthcare providers had standing to make the argument. It wasn't specifically raised in the Supreme Court, but they approved that decision.
I mean, the Supreme Court was actually pretty clear on what the issue was, and even narrowed the question. It said what the issue was. It had to do with just the presumption, and then they narrowed the question whether the first DCA interpreted the term immediate post-delivery period in the hospital as that term is used too expansive.
That was a separate issue. There were two separate issues. So the one was the immediate post-delivery period, and the second one was the rebuttable presumption. And in the context of determining the rebuttable presumption, it acknowledged and approved the procedure whereby someone files a petition under.
Did it approve or just not challenge it? I mean, because you can consider a situation where, like, just say this one, where the parent files a claim for compensation, does it under protest, says, I'm not presenting any evidence because I think this whole thing is out of order, have at it, and the providers come in because they intervene, which they're entitled to do, and present the evidence. Doesn't Bennett just kind of address that scenario where, okay, in that situation, the presumption doesn't apply because it's not the claimant seeking to prove?
No, I don't think that that's right. I think that they acknowledge the fact that petitions need to be filed under protest. It doesn't alleviate your responsibility to do that because the ALJ has exclusive jurisdiction to make that threshold determination before a civil action can proceed.
Whether a claim is compensable.
Correct. And so.
So then, how, at the end, though, where does the Supreme Court say that on appeal, the provider has standing to challenge a determination of non-compensability? Or in other words, that the provider is adversely affected?
Well, I think that it's just implicit in the holding on the rebuttable presumption by recognizing that a petition is filed under protest, and when that is done, the burden of proof shifts to the healthcare provider or NICA, and the rebuttable presumption of compensability doesn't
But that's
apply.
standing in the administrative proceeding. I'm talking about on appeal.
Well, I mean, I think this court is the first one to raise an issue about jurisdiction on appeal, despite every other appellate court's independent obligation to determine its jurisdiction. One can reasonably assume those courts did fulfill their obligation and determined that they did have jurisdiction to make those decisions. One other thing.
This brings up a question. Is this an appeal proceeding under 12068-1, or is this an appeal proceeding under 766.311? Because within
it's
the
under
NICA
both.
within the NICA statutes, the legislature gave a standalone appeal right. So is it proceeding under, like, that's the avenue?
I think
the
it's under
basis for our
both.
jurisdiction, because it says, you know, review of the order shall be by appeal to the DCA. Is that the basis for our jurisdiction?
I think it's both, because the 760, the provision saying that you have to appeal to the District Court of Appeal is certainly a jurisdictional provision saying this is how it's going to be reviewed. But it's also clear that Chapter 120 applies to NICA proceedings, and that's not.
Where is that? Where is it? What provision says Chapter 120 as a whole applies?
There is, I don't have the specific site, I can provide it to the
There's language
court.
in 304 that says the administrative law judge shall hear and determine all claims and shall exercise the full power and authority granted to her or him in Chapter 120. So that talks about
That
how
makes
the
120
ALJ
apply.
operates, but it doesn't say the full scope of Chapter 120 applies to these proceedings.
Well, I know, and I don't have the case in front of me. There is a case, and I can provide it after this if you'd like, that says that 120 applies. But, I mean, I don't see that, I'm not sure I understand the meaningful distinction between that, whether it's under 766 or 120, because either way, you can,
If
you
it's under
appeal to this court.
12068, then you have a party adversely affected. If it's under 766.311, then you don't have the adversely affected language. I want to understand exactly what this is appeal is proceeding under, because it appears, the legislature in 311, that's where they seem to give the jurisdiction to this court to review these decisions.
I definitely agree with that. That's not a question I have fully thought through, because the way I was looking at it is that 766.311 certainly gives jurisdiction to this court to review NICA, to review orders from the ALJ. And the way I was reading the cases and the statute is that 120 also applies, but I don't have a specific
It applies
answer.
for the powers of the ALJ, and, it appears to apply to, the power of the ALJ and how they run the hearings and the proceedings. But it's not wholesale, it doesn't appear to be wholesale. In other statutes, you see the legislature, like, all these proceedings, shall be conducted under Chapter 120. It's just worded differently. than
No,
how you
I
see
think
it.
that, I see what you're saying, and I think I would have to, and I haven't thought this all the way through, but I would think that if we're proceeding under 766, then that provision would be the one that provides the appellate court jurisdiction. I know I'm over my time. If I could just make one more point, or? no?
Very quickly.
Okay. So the opposing counsel made the point that words matter, and they do matter, but the whole text canon of construction is a textual canon of construction, which means that you don't take a sterile, literal interpretation of certain words in a statute. You would look at the entire context of the statute. And we set out in our motion how the entire context of the statute requires that the plan be exhibited this way, or fulfilled this way. And when you're looking simply at for compensation, I feel like it's being given too much weight especially when viewed in the context of the plan. Because a petition, if you're required to file a petition seeking compensation,
Ms. Davis.
then you can do it, and otherwise, you, doing it under protest. So it's still for compensation.
I think we understand what you're saying.
The last thing I would say is that it is clearly in conflict, and so at a minimum, we would ask the court certify conflict, so this can be decided by the Supreme Court.
All right, thank you very much. I want to thank all the counsel that appeared today for their excellent oral arguments. We are adjourned.
All rise.